he's gonna sell it. I'm just test driving it.
Are you now? Okay, but you just said this is your car.
No, it's, of course, I'm driving it, so I have to have insurance on it and stuff.
Okay, you said this is your car. I asked you if this is your vehicle, and you said yes. So there shouldn't be a reason why you should have a dealer tag on there just because your husband.
Well, right now I'm driving it, so it's not like. Do you want me to call my husband? You can talk to him.
I'll go off of what you tell me. You tell me that this is your vehicle. You still live on Country Place Road?
Yeah.
All right, bring it back with you.
Uh-huh.
Here you go. Make sure you wear your seatbelt also.
I swear I was wearing.
Make sure you also start driving cars if it's not.
Huh?
Dealer tag. Put a real tag on your vehicle, not dealer tag. Okay.
Okay, but I swear I have. Okay.
It's 10:52 on a weekday morning in Fresno, California, and a police report will later read, "Vehicle stopped for equipment violation. Headlight color." That's it. 4 words that were supposed to end this stop in 90 seconds. Instead, they open a case study in what happens when a badge collides with a driver who came prepared. Picture a set of headlights, like a lie detector wired to the front bumper of a car, glowing exactly the color the law allows, and still somehow becoming the excuse for 6 separate stops by 6 separate officers, all convinced the light itself was the crime. That's the visual to hold on to, because everything that follows hinges on it. Before we go deeper into what the dashcam actually shows, make sure you're subscribed to Police Misconduct Case, because we don't just cover the story, we follow the evidence. The driver is identified in his own footage only as Mr. Chavez. The officer identifies himself as Officer Lamella, Patrol Division. And what unfolds over the next several minutes isn't a chase, isn't a struggle, isn't even a raised voice. It's something quieter, and in its own way, more damning. A uniformed officer standing in front of a civilian who has already been to court, already has the ruling, already has the statute number memorized, and watching that officer choose ego over evidence anyway. Start with the stop itself. Officer Lamella approaches the vehicle and tells Mr. Chavez the headlights are the problem.
This first video comes to us from Tigger Maddie's channel and shows Miss Maddie test driving a vehicle from her husband's car lot where she is stopped by a Montgomery County Sheriff's deputy in Montgomery County, Texas.
Are you pulling me over?
Not broken, not too dim, too yellow. He cites California Vehicle Code Section 25950, which does exist, and which does say that light emitted from lamps and reflectors visible from the front of a vehicle shall be white or yellow. Read that again. White or yellow. The statute doesn't rank one above the other. It doesn't say yellow is provisional, or yellow is suspicious, or yellow requires further inspection. It says white or yellow. Full stop. And Officer Lamella is standing on the hood of a legal ambiguity that isn't actually ambiguous at all. This is where the irony starts to compound, because Mr. Chavez isn't a driver caught off guard. He tells the officer, on camera, that he's already been stopped for this exact issue before. He's already been to municipal court over it. A judge has already reviewed the statute, reviewed the equipment, and ruled the headlights lawful. He says it plainly. He checked with a sergeant at the district, he checked with a watch commander at CHP, and every one of them told him the lights were fine. That's not a driver making excuses.
I just took my seatbelt off as a habit. Yeah, I just took this off, just so you know. I wasn't driving without a habit. Huh?
That's the reason you're being stopped.
No, I just took it off.
Miss Maddie is attempting to be honest with the officer, but the officer takes advantage of her honesty and considers it an admission of guilt. As noted earlier in the video, the officer passed Miss Maddie going in the opposite direction and could not have had a better view of the seatbelt if that's what he was looking for. It is important to never give an officer more information than is absolutely necessary, and Miss Maddie's quick defense only served to arm the officer with reasonable suspicion. Without her dashcam, Miss Maddie would have no evidence to support her claim, but her nervous and defensive body language could have been used as evidence to justify the officer's suspicion.
I swear to God, it's habit. Yeah. I wasn't speeding.
Oh man, I'm gonna tell you the reason you're being stopped today because you can have a seatbelt on.
No, I just took it off. I swear to God, I have a camera.
Yeah, so your
I have a
license plate,
camera.
your
I
insurance
can
card,
play it for you. Because it's habit. When I stop the car and put it in park, I take it off.
There you go. Thank you. Is this your car?
Yeah.
What do you have to do tag
Because my husband owns a dealership.
on? Okay. So does that mean you can just put dealer tags on any vehicle that you own?
No, we're
Because
gonna
dealer
sell
tags
it.
are usually whenever
Yes.
for a dealer or if they're showing the vehicle.
Yeah.
It's just neither of them.
That's a driver who did exactly what the system tells you to do when you have a dispute with law enforcement. He took it to a courtroom, got a ruling, and has been carrying that ruling around in his car ever since, like a receipt he shouldn't have to keep showing, but does anyway. And here's the moral center of this entire case, the phrase worth sitting with the first time. A badge is not a higher court. Officer Lamella, in the moments that follow, effectively tells Mr. Chavez that a municipal judge got it wrong. Not directly. No officer says the judge is wrong out loud, because that would make the overreach too obvious, even to him. Instead, he does something more familiar to anyone who's watched enough of these interactions. He shifts the argument. When Mr. Chavez points to the plain text of the statute, Lamella pivots to a different clause, something about altering the performance of the lighting equipment, a phrase that appears nowhere in the section he originally cited. When Mr. Chavez asks him to point to the specific statute that prohibits altering headlight color for performance reasons, Lamella can't produce one, because there isn't one. Independent review of the California Vehicle Code turns up no provision prohibiting the modification of headlight color to affect brightness or visibility, provided the resulting light remains white or yellow. The officer is not enforcing a law. He is enforcing a feeling.
Decided to focus on a different aspect of the stop. According to the Texas Department of Motor Vehicles website, a dealer tag can in fact be used by the dealer's family or employees for personal use. This officer frankly doesn't know what he's talking about and is presenting his speculations about dealer tags as facts.
No, he's gonna sell it. I'm just test driving it.
Are you now? Okay, but you just said this is your car.
No, it's, of course, I'm driving it, so I have to have insurance on it and stuff.
Okay, you said this is your car. I asked you if this is your vehicle, and you said yes. But there shouldn't be a reason why you should have a dealer tag on there just because your husband.
Well,
owns the
right
dealership.
now I'm driving it, so it's not like. Do you want me to call my husband? You can talk to him.
I'll go off of what you told me. You told me that this is your vehicle. You still live on Country Place Road?
Yeah.
All right, bring it back with you.
Uh-huh.
Here you go. Make sure you wear your seatbelt also.
I swear I was wearing.
Make sure you also start driving cars at this time.
Huh?
Dealer tag. Put a real tag on your vehicle, not dealer tag. Okay.
Okay, but I swear I have. Okay.
Ticking clock moment. Because this is where the stop stops being a headlight dispute and becomes something closer to a test of the entire framework governing traffic enforcement in America. If an officer can override a documented court ruling using nothing but his own reading of a statute he's misquoting in real time, what exactly is stopping every traffic stop in this country from becoming a matter of personal opinion instead of publicly written law.
Next video from Sean Chavez's channel also centers around an officer's misinterpretation of the law and perfectly demonstrates the accountability a dashcam offers when officers are uncooperative and
used against him later. A badge is not a higher court. If Officer Lamella were confident in his interpretation of the statute, a citation would be the fastest way to prove it. Let a judge decide, again, on the record. Instead, the stop ends the way 6 previous stops apparently ended, with no citation, no documentation, and no accountability trail for the department to review.
25950 clearly states that emitted light from all lamps and reflectors visible from in front of a vehicle can be white or yellow. Mr. Chavez has the court documents and the exact statute on hand ready to show Officer Lamella, but the officers...
Because that's the deeper story here, and it's the one that should concern anyone who thinks this is just a headlight dispute. Mr. Chavez tells the officer, plainly, that this is the 6th or 7th time he's been pulled over for this exact issue. Officer Lamella's response is almost reflexive. He says he's never personally stopped Chavez before, as if that settles the matter. Consider the framework the courts have built around exactly this kind of officer error. In Hyen versus North Carolina, decided in 2014, the Supreme Court held that a reasonable mistake of law by an officer can still justify a stop. Meaning an officer who misreads a statute, in good faith, isn't automatically committing a constitutional violation just because the underlying legal theory turns out to be wrong. It's a doctrine built for genuine, honest confusion. But that doctrine starts to strain under repetition. One officer making one honest mistake about a statute is a footnote. 6 officers making the identical mistake about the identical vehicle over the identical time period after a court has already resolved the question isn't a string of coincidental misunderstandings. It's a training failure the department has had every opportunity to fix and apparently hasn't.
My partner's going to check your license, make sure it's all valid.
Lamella now believes that he has a greater understanding of the legalities surrounding this interaction than both a municipal judge and multiple fellow officers, including the head of his district and a watch commander. Officer Lamella's pride and ego are clouding his ability to objectively perform his duties and uphold the language of the law instead of his personal interpretations of the law.
Mr. Chavez says it himself, on camera, in the calmest possible terms. This is harassment, and it's coming from the department, not from any one officer. That's an important distinction, and it's one worth sitting with, because it's easy to make this story about Officer Lamella's ego, and his ego is certainly part of it. The refusal to run the section number, the refusal to accept a documented court ruling, the pivot to a non-existent performance clause when the plain text didn't support him. But the harder truth is structural. If a department's training doesn't include, check whether this driver has already litigated this exact equipment issue before initiating stop number 7, then no individual officer's good intentions matter. The system produces the same outcome every time. A lawful driver stopped repeatedly for equipment that has already been ruled legal, with no citation ever issued to create the paper trail that might finally force a review.
Cannot justify an investigatory stop. This ruling grants officers a poorly outlined margin for error that can act as justification for improper traffic stops and indirectly encourages officer ignorance.
A badge is not a higher court. That's the second time. Sit with it, because it's the fulcrum this entire interaction turns on. Every time an officer treats his own reading of a statute as superior to a documented judicial ruling, he is functioning as judge, jury, and enforcement all at once. A concentration of authority the framers of both the Vehicle Code and the Fourth Amendment never intended for a routine equipment stop, and without unreasonable seizure. Whether a court would ultimately agree is a separate question from whether the pattern deserves scrutiny. Courts evaluating repeated stops of the same individual, it doesn't, because the claim was never that one officer was targeting him. The claim is that a department, Fresno PD, has across 6 or 7 separate stops by 6 or 7 separate officers never once corrected the underlying misunderstanding about what the vehicle code actually says. Every new officer who runs Mr. Chavez's plates and sees yellow headlights apparently starts from zero, unaware that a municipal court has already ruled on this exact equipment, unaware that the vehicle code doesn't say what they think it says, unaware that stopping the same driver for the same lawful equipment